Hello everyone and welcome to Uncivil Law. For today's case, we have the case of Maria Mercedes Casino versus Cameron County, Texas. This is a decision from the Court of Appeals for the Fifth Circuit. In today's case, a prisoner escaped during transport and caused harm to other people. Those people are suing on the basis that they were harmed and are suing the state for the responsibility. The question is the state responsible for any of this as a result of this prisoner's action? So let's get started with this. A jury convicted Michael Garcia of burglary and 3 counts of aggravated assault with a deadly weapon. Following his conviction, the Cameron County, Texas Sheriff Department assumed custody of Garcia while he was awaiting sentencing. Prior to Garcia's sentencing, Antonia Tella, an employee of Cameron County Sheriff Department, transported Garcia to a dental appointment in Brownsville, Texas. Garcia overpowered Tella in the dental clinic parking lot and escaped with Tella's handgun and service belt. So while going to a fairly routine dentist visit, the prisoner was able to overpower his guard, take his belt and his handgun. Not such a great start. After escaping from his guard, Garcia forcibly entered a home where he encountered Mario Martinez, Martinez's wife, Maria Mercedes Casino, and Julian Puga. Garcia used Tella's handgun to shoot Martinez, who ultimately died from his wounds. Garcia then held Casino and Puga at gunpoint and forced them to hand over the keys to a car parked at the home. Garcia left the house in the car and a high-speed police chase ensued, ending in a shootout during which Garcia was fatally injured. So this prisoner took the handgun, he entered a home. For reasons that are not apparent, at least on this record, he shot one person, he took the car from another person, and then proceeded on a high-speed chase where he ultimately died. Puga and Casino, acting on her own behalf and as a representative of Martinez's estate, sued Cameron County, Tella, and Omar Lucia, the sheriff of Cameron County. The plaintiffs brought claims against all 3 defendants under 42 U.S.C. 1983 and also asserted claims against Cameron County under the Texas Tort Claim Act. The plaintiffs derived their 1983 claims in 2 counts, a state-created danger count alleging that the defendants violated the 14th Amendment, constitutional right to be free from state-created danger, and a shocks the conscience count alleging that the defendants' actions violated all plaintiffs' 14th Amendment rights to life and bodily injury because they shook the conscience. So the question is here, did the state create the danger that caused this injury? And if so, is the state liable? There's a division of authority on this issue, and so Texas and the Fifth Circuit is going to cover the law that applies to its jurisdiction. Under the state-created danger doctrine, which has been accepted by some of our sister circuits, when state actors knowingly place a person in danger, the Due Process Clause renders them accountable for foreseeable injuries resulting from the conduct. However, our decisions have consistently confirmed the Fifth Circuit has not adopted the state-created danger theory of liability. Although we have outlined the contours of the state-created danger theory in numerous cases, we have never adopted the theory even where the question of the theory's viability has been squarely presented. The plaintiffs failed to allege that the defendants were aware of an immediate danger facing a known victim. Although the plaintiffs allege that the defendants were aware of the danger that Garcia would present if he were to escape, they do not allege the defendants knew about an immediate danger to the plaintiff's safety, nor can the court infer such knowledge from the pleadings. It is not enough for the plaintiffs to allege the defendants knew a risk of a class of people that include the plaintiffs, namely people whose geographic proximity to the dental clinic put them into a zone of danger. Rather, to fall within the scope of the state-created danger theory as we have explained it, the plaintiffs must allege defendants were aware of the danger to the plaintiffs themselves. So in the Fifth Circuit, which has not adopted this theory at all, they have put in language in other cases that say, well, if we were to adopt this theory, the way we would apply it is by saying you would have to show actual danger to the actual people that are being hurt. The state was aware of that actual danger to these actual people and did not do enough about it. But they're saying that's not the issue here, because at the time of the incident, the state was not aware of these particular people, or that they would be particularly hurt. At best, they would be aware of perhaps dangers to the dentist and his staff, people there, and perhaps even people who were visiting that. But the idea that he was in a danger to anyone in particular in a neighboring neighborhood obviously doesn't quite flow from that. And so they're saying, well, even if we were to adopt this theory, which incidentally we're not, it still wouldn't apply because you haven't shown any danger that the state knew about to these particular people. And so as a result, in our law, we say that there's no recovery available here. Although the defendants may have been aware of the risk that Garcia would pose to unidentified individuals within a certain distance from the dental clinic, Although the defendants may have been aware of the risk that Garcia would pose to unidentified individuals within a certain distance from the dental clinic if he were to escape, they were not aware of a risk to the harm to plaintiffs themselves. Accordingly, the defendants' decisions, while ultimately tragic, were not sufficiently willful and targeted towards a specific harm to fall within the ambit of the state-created danger theory of liability. As a result, even if we were to embrace the state-created danger theory, the claim would necessarily fail. So that is the end of the case of Maria Mercedes Casino versus Cameron County, Texas. In this case, we learned about the state-created danger doctrine. A state-created danger doctrine has been adopted in some jurisdictions and not others. And most critically to our analysis today, it has not been adopted by the Fifth Circuit as a theory of state liability. However, the Fifth Circuit has said in prior cases and reiterates here that if they were to adopt it, they would require some specific knowledge to the particular people who are being injured, and that it would have to be foreseeable danger to these people in particular that the state was aware of and chose to ignore. And here they can't show that because there was no specific danger that could be foreseen to these particular individuals, maybe to a class of people that were nearby, but that is insufficient to show the state-created danger doctrine according to the Fifth Circuit Court of Appeals. So as a result of this, there is no recovery under 42 U.S.C. 1983 for the harm caused by this prisoner, and that is the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.